Good morning, good morning, good morning. It's Tuesday. It's still July. It's July 22nd. Emily, what are we talking about today? Well, we are going to be talking about what is going on in the Kohberger case. Tomorrow is the sentencing hearing in the Bryan Kohberger case. So ahead of tomorrow's sentencing, there are things that happened while I was traveling at the end of last week. There are new motions. We need to talk about the new motions. So we have quite a lot to talk about today ahead of that sentencing tomorrow. Also, today is the day that the first appearance on the juror that was a grand juror during the time that Karen Reed's grand jury was also convened, that the media is reporting was a part of the Karen Reed grand jury. And it seems like that is a realistic possibility, though grand jurors, of course, sit on more than one grand jury. That first court appearance is today. So we will see what happens. If there's anything in Pacer at the end of the day, I'll take a look. I'll let you guys know at the app. But today and tomorrow, we are just talking about Kohberger. So that is what we are doing ahead of that sentencing because, well, there's a lot going on in that case. And it's just a lot. And there's still a lot I see of questions, confusion, and just a basic, like, what the heck is happening? So with that, we're going to roll the intro and we are going to get into it. We've got lots to chat about. Let me know where you're coming in from, what you're drinking. I've got a cappuccino. We have a hearing we need to get to today. So we're going to get to that hearing first, then the documents, then the questions. So replay crew, love you. Everything will be timestamped down below for you if you want to jump, or like House of Pain, jump around. Emily, are we just going to quote Boston things all day today? Well, did y'all see the Boston Crusaders squeaking out a win in San Antonio? I know. The season's getting very interesting. It might be Boston's year. Emily, aren't you always cheering for the Cavaliers? I'm always cheering for the Cavaliers. I love their show. I think it is a great show. I think it is fantastic. However, where we are seeing things moving, it is realistic that it is Boston's year. And that's just me being realistic. It doesn't mean I don't love the Cavaliers show. It's my favorite show. It is so good, but I am not a judge. I am a mom, but Crusaders, man, they're coming. Blue coats are probably not super thrilled, but Boston's coming. I think it's going to be their year. So let us roll the intro and get into it. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. So yes, lots is going on in Boston. With that, the Boston Crusaders again are the DCI Drum and Bugle Corps. They're not like marauding Crusaders running around Boston. I realize that could potentially be confusing, but yes, Emily, is your brain just in the world of drum and bugle? Yes, we're in the DCI brain. Why? Because all I have been doing lately is watching shows. So it's been fantastic. I get to see my kiddo, which with the Kohberger case, honestly, bookending it with seeing my kid was 100% necessary because I don't know if I've been able to like talk about all of the stuff without getting to go like physically hug my kid because this case is heartbreaking. The Idaho prosecution of Bryan Kohberger is it's just heartbreaking, and it's really hard to watch, though necessary to watch, the pain that the parents, families, and loved ones are going through. Sentencing tomorrow is going to be hard. We are going to timestamp all of it. It is going to be a hard day. It is going to be an emotional day. And I think for many, it's going to be an unsatisfactory day because the expectation and desires and the want to have an explanation and a reason is unlikely to be met. So a lot of people hope that Bryan Kohberger will explain why. I don't think that is a realistic expectation. I don't think we will get an explanation. I don't know if there is an explanation because really there's not a reasonable explanation for why you slaughter 4 people. There's just not. There is nothing that makes it okay. And there's nothing that's really going to be understandable because it's not something that people who are oriented to the world of morality the way most of us are would do. So an explanation is still not going to make sense even if there were one. And I would just point back to the letter from Brian Laundrie talking about Gabby Petito. There was a letter. He had an explanation, but that explanation isn't oriented to reality. So, or what we know the facts to be. And it's not helpful to just have someone gaslight everyone and be like, well, that's not accurate. So sometimes the answers that people want the most aren't going to come. I hope that the plea and the fact that Brian Kohberger will spend the rest of his life in prison, and the fact that, well, I wish I could say we would close the laundry. No. Yes, but no. I wish we could close the chapter on this case and let the families heal, but we know that that's not what's going to happen either. This case is not going to be done just when it's done. So when Brian Kohberger is sentenced tomorrow, I think it'll be tomorrow. I don't think this will go over into Thursday. It might, but I don't think that it will. When Brian Kohberger is sentenced tomorrow, potentially Thursday, and the door is closed on him, the door won't be closed on this case because there is not enough known still. We're going to talk about that today about unsealings. There's not going to be the type of closure a lot of people might want, and there's still going to be a lot of discussion of this case online, in the media, in docuseries and books and the rest of it that aren't going to be helpful. So when we look at what happens at sentencing, we are looking at the formal sentencing. We know what the sentencing is going to be. We know that he is going to get 4 consecutive after each other. Fixed, meaning determinate life sentences. Other jurisdictions call that different things, but a fixed life sentence means that the sentence is fixed for an amount of time. And the fixed amount of time is for Brian Kohberger's natural life. So a fixed sentence for life means it is fixed until he is no longer alive. So fixed life sentence, 4 of them consecutive, one after the other, plus 10. And we know that there will be impact statements. I don't know everyone who will make an impact statement. We will see them as they go. We know the defense will have time to make a statement. I don't think we will see much from the defense because they've already made their record. So Aaron in the chat asked, so the only way Brian gets out is through a pardon, or is that also not an option? I can't see that happening. If theoretically it's possible, I don't see that happening. I just don't see that happening. This is not a case that is reasonable for a pardon. I just can't see that happening. The Lauren said, Emily, is there no way that he can get a lesser sentence? It's an agreed upon plea. So no, there is no way he is getting a lesser sentence. It's an agreed upon plea. So he's getting 4 fixed life sentences. That is the plea deal. Of course, the judge does not have to honor that plea deal, but if he doesn't honor the plea deal, it will get revoked and then it'll go to trial, and that's not going to happen either. Those aren't things that are going to happen. This is going to go forward. So he is going to be sentenced tomorrow or Thursday. And again, that is a fixed life sentence. So fixed at the natural course of his life. So he will be done with this sentence when he is no longer alive. So with that, we are going to watch the hearing that was it Thursday? The 17th? I don't know what day it is. We're going to watch the hearing we're going to go through the filings. We are going to answer a lot of questions because there are so many questions. And that's what we're going to do. So I saw a couple of you asking about him withdrawing his plea. I don't expect him to withdraw his plea. The court will not accept a withdrawal of plea at this point. The only way the court would accept a withdrawal of plea is, well, speculation doesn't help, but there's no circumstance that is known to us at this point that indicates that he will withdraw his plea. I realize that might be a spectacular, like, clickbait title to a video, but the court has a very normal process, and everyone has signed this plea deal. The court has given all the advisements. The plea has been entered. So are there outside possibilities? He can ask. I don't think the judge would allow it. It would have to be, well, I think any circumstance that I can think of off the top of my head would be malpractice. Because all of the circumstances would be known to the defense. Unless the freaking prosecution did something wild, and I don't think that either. So that's what we will see. All right. So we will get into all of that. Thank you guys for staying on topic. I know a lot of you are asking me about other stuff that's going on in Boston, Adam Lally testifying regarding discovery and what have you. We will do it another day. We have a lot going on today with Kohberger, and we have a lot going on tomorrow with Kohberger. Adam Lally he's not going anywhere. It can wait till another day. We will talk about it another day. Court has a process, and a fairly normal process. This case is going to run along that fairly normal process. So what about this and what about this and what about that? Most of it's not even within the realm of possibility. Judge Hippler's not going to sentence him to something outside of the arranged plea agreement. Could he? Theoretically, he could. Is he going to do that? No, he's not going to do that. That is not going to happen. It is not realistic. It is not even within what I would think Judge Hippler would ever consider. If Judge Hippler wasn't going to accept the plea deal, he would have told them. And he's not going to. So with that, we are going to get into that first court hearing. I'm going to save questions, and we're going to get through those when we get to Q&A. But before we do all of that, we do have a stream sponsor that I want to thank before we get into the court hearing. So before we roll into court, if you guys like to play in the background on your casual mobile games, I've got a game for you. Well, Honored, the question I've been getting a lot is, with trial done, what next? And I suggest maybe it's time to solve some mysteries. No, not online and not now. How about in the 1920s? Because June's Journey, today's sponsor, brings us a gripping mystery that's also a hidden object game. And there's a little bit of a timer element, and I get very competitive with myself, so I find it completely engrossing. And sometimes when I'm like, I don't need to find objects, I need to place objects and decorate, I have a really good time decorating all of the things. And then with special events, you can get other decorative items. Plus, as you're going along, you're finding clues and trying to solve the mystery, which is much more satisfying than waiting to find out what's happening in all of the cases I'm covering. So if you are ready to solve a mystery, looking for something to do during stream, or just want a fun way to challenge yourself to see how good you are at hidden objects, June's Journey has something for you. And you can download June's Journey right now for free from the link down below or the QR code on the screen. You can just go ahead and scan that. So just point your phone at my face. I mean, the QR code, it's to the side of my face. And you can download June's Journey and join me in playing along. It's available on iOS and Android, and you can play on PC. Thank you so much to June's Journey for sponsoring this live stream. I'm going to go ahead and put my phone down, and we're going to get back to stream. I swear I'm not playing in the background while that ad's running. Okay, a little bit. I'm a little bit playing in the background while we're doing it. So for that, we are going to go to court. I appreciate all of our stream sponsors. I appreciate June's Journey for sponsoring. It's a fun game that I very much enjoy. So you guys, to court with Judge Hippler from Thursday. So we need to, well, we're not bringing the jury, but
the jury.
We miss it. We miss it. You will notice everyone is on Zoom. Why is everyone on Zoom? This was a more last minute hearing. This was a Zoom hearing. So we are going to go, I can't really put up live court because we're not live. So, well, I'm live. Court's not live. Court was live on the 17th. A lot of you have probably heard this hearing or seen my updates on the outcome of this hearing, but I still think it's important to go through this hearing together and answer the questions. So we're going to do that first. Then we are going to get into all of the documents. You will see that there is discussion about unsealing. We will talk about unsealing. There is a objection to this from the defense. We're going to talk about the defense's objection to this, because why would the defense object? We're going to hear some of that. So let us go to court together from Thursday. And then, well, tomorrow we will be in court. If you are just tuning in, tomorrow the sentencing is scheduled to start at 9 a.m. local time, so 10 a.m. here. Sam, no, the judge is not in chambers. The judge is on the bench in his courtroom. Everyone else is on Zoom. So the judge is looking at his monitor, and you can see that the judge has a little like webcam for the judge, but also a camera that they use to stream in court. So tomorrow we will be live at like an hour earlier than I normally am at, well, at 10 a.m. Central. So tomorrow is live. I will be live and covering it. We are going to put it on a very slight delay so that we have closed captioning, because it's going to be a long day. It is going to be an emotional day, and I think closed captioning will help. The court does not send out their video with closed captioning, so we are going to take care of that on our end so that we can have closed captioning. So we will be just a touch behind real time tomorrow, but not by much. We just want to make sure that we have that. I think it's like a 40-second delay so that we can have closed captioning in real time tomorrow. So that's our goal. All right, let's go ahead and push play on court and go to court. I will be pausing and chatting, but this is the hearing regarding the gag order. And that was in yesterday's Emily show that dropped. I talked a little bit about it. So that audio is not going through the right place for me. So let me shift that one more time. Emily, does everything get shifted when you travel? Yes, because I unplug things and then I have to replug things, and then sometimes I mess it up. So Tanya said, anyone know what time for the UK? I go live at 11 normally. So 1 hour before I normally go live, 1 hour earlier. So whatever time it is now, an hour and a half earlier than that. So whatever time it is where you are right now, an hour and a half earlier. Hopefully that helps. And if you get the Law Nerd app, you'll get a notification.
On the record,
there we go.
State v. Kohberger CR 0124 31665. Present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order.
So for those of you asking, Wendy Olson is the same attorney that represents the university professor in that defamation case. So if you recognize the name, that's why you recognize the name.
The state filed a response indicating it was no longer objecting.
Judge H is incredibly thoughtful, but there are times I just want to speed him up.
To that.
So yes, we are just riding it out.
And the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things.
For all of you asking, Kohberger is in his jail clothes, and that's what he's going to be in tomorrow. So He's in, however, I don't know how Idaho uses different colors to designate. I have no idea. I'm not going to speculate on it, but he's in whatever he wears every day in jail. That's also what he'll be wearing tomorrow. He's not going to be in street clothes tomorrow.
Share a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
I said the judge is going to be like, I got your briefs. I got your briefs. So let's go. So I'm not surprised. He said, I don't need anything more from the media, but let's hear from the defense.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Wilson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here because that was about information provided to the court. And given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that...
Emotions are high. Emotions are going to be high, whether it's at trial, no matter what. Emotions are going to be high in this case. It's a really brutal quadruple homicide of 4 young people. I struggle to not call college kids because I don't want to be patronizing in it, but they are young college students. Of course, emotions are high. People are pissed, but emotions aren't going to be less high. And I think a lot of people feel very, A, protective, and B, this is a horrific crime. And it taps on almost everyone's fears that you're going to be at home in your bed and something's going to happen. And it taps on every person's, like every parent's fear. It taps into the fear of young individuals who do not feel safe in this world. It really crosses all kinds of thresholds of personal safety and then just the absolute lack of control. And it's just, yeah, emotions are high and people are mad about this plea deal. And so emotions are going to be high. The media can tune that up. And I think that they often do. This is one of my critiques of a lot of media, is that they lean into the emotion and ramp it up. However, that's going to happen whether or not there's a non-dissemination order. That's going to happen either way. Grief is a hard thing for humans to deal with anyway. Grief gets a little easier when people have lived a full life and you're like, okay, they lived a full life. They are loved and appreciated, but I understand that life is not indefinite. The thing is, when people do not have the ability to live that life, that kind of grief hits differently. right? And it hits everyone differently. So yeah, emotions are high. And also the internet can be wild and can lean into those emotions and heighten them in ways that aren't helpful or healthy to deal with. Also, grief begets other grief. Grief is just a fucking difficult emotion because it dredges up so much other grief. So the grief in this case, for everyone that comes across this case, can dredge up other grief because it does that. It just drags it all up from the bottom. So, yes, defense, emotions are high. The brutal loss of life is high. And it's absolutely senseless. And it's a complete violation of things that should be safe. So, yeah, emotions are high. Sure. But that doesn't mean that the media doesn't have the right to question people about what happened in this case. So, they do. And we're also looking at a generation of kids that has been so devastated by remote learning and the separation from their communities. And though that happened to all of us, it hits different for kids who were in elementary school, junior high, high school, college. So to finally come out of that and get back to the socialization that they should have, the times to grow up that they should have, and they didn't because of him. So yeah, emotions are high. Don't murder people. Emotions will be less high. But the media not having a gag order doesn't change those emotions. So, yeah. Emotions are going to be high. All right. Continuing on. Emotions are going to be high. Emotions are high in criminal cases. That's true in every criminal case. It's just how many people are feeling those emotions. So, BW said so true. These are COVID high school kids. Yeah, they need, look, I'm not going to debate COVID. I am going to say that from watching my own kids, it road bumped what growing up and what the getting to build community looks like. And that's a thing everyone's going to have to overcome. And it made a lot of young people a little bit more cautious in big groups. There was a lot for people growing up and developing during that time. And there's grief around that too. So, yeah. Emotions are high. This is an emotional case. It's not going to not be an emotional case. Tomorrow's going to be an emotional day. And sometimes when people are grieving, they run into a lot of anger. And sometimes anger is just the easier and more accessible emotion. So when the defense is saying emotions are high, I think they are talking about rage. Sometimes that is an easier emotion to tap into. Sometimes it's more comfortable and more comfortable to tap into because the sorrow sometimes is too deep. So rage kind of comes in and covers that. But this case hits people sideways. And it's hard. And people have the right to be mad or sad or mournful or disappointed. People have the right to their emotions. But this case hits on a lot of different things for a lot of people. So when the defense is like, this case is, there's a lot of emotions. Yeah, there are. Yeah, there are. There are a lot of emotions. And that's okay. It's okay to feel the emotions. For those of you that are working tomorrow, if you are a sympathetic crier, I'm a sympathetic crier. The first person whose voice starts to break tomorrow, I'm out. I'm just going to sit here and cry with y'all. That is how it's going to be. Just, there will be tears. But we're going to timestamp everything so that we can skip if you need to. So let us continue. I'm going to save all your questions and we will continue with this hearing. But yeah, defense. There are emotions. Of course there are. I'm going to back up what the defense was saying. That's not a reason, by the way. Just because people have the feels is not a reason to keep a gag order in place, by the way. That's not like grounds. That's vibes. And Judge Hippler is not a vibes, Your Honor type of judge. Most aren't. Some are more amused by the vibes argument, but Hippler's not a vibes guy. Hippler's a, where is it written? Where is the word written down on the page? Samantha, me as well. Oh, yes. Which, you know, when you cry over commercials, that they have built those commercials to garner that response. There are whole areas of study. They lean into that to try to garner that response. I also hate it. Then again, I also cry listening to music. So it just is. Continuing on.
Scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients.
And that
Thank you,
is
Your Honor.
the media's attorney. We're going to the defense
in light
attorney.
of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
This is from the defense.
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you.
That's not a valid legal reason.
All right.
Here's what I think the defense is asking in that. The defense said emotions are already high. They are talking about the sentencing hearing for tomorrow, and a rush to interview people could heighten those emotions. I think the defense is stepping around security concerns. I think they are trying not to say out loud that they are concerned for Brian Kohberger's safety in court during the sentencing hearing because emotions are high. However, that is not what the law allows. And I don't think that feeling or sentiment or the emotions of this case are going to change because those who want to speak to the media can, and those who don't want to speak to the media don't have to. Lifting the non-dissemination order means that those who want to talk can choose to. Static Glass Creation said, why not just say that though? Because the court knows what they mean and they don't want to say that knowing that this hearing, and this is my speculation, knowing that this hearing is public because they don't want to put that out there too much. But it is a concern, and it's something that the court staff is already planning for and concerned for, I am sure. It's already a concern. But that doesn't change whether or not a non-dissemination order in place. That is a courthouse security situation.
As the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order.
We know. We said that.
In order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury,
Right.
is any longer at play.
Correct. Right.
The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless.
Correct.
It is a little bit like
Correct.
water will find low ground. In this case, the media is going to write about something regardless.
The media is going to write about something regardless because water is going to find low ground. Exactly. They're either going to reach out to interview somebody or not. They're going to do whatever either way. And the law does not allow for the non-dissemination order to stay in place.
About this case,
Right.
the lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated that they don't intend to until after the sentencing.
Fine.
And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out
Disturbed.
unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of.
The court was looking for the right word because I'm sure the word that the court wanted was not what he wanted to say. So the court was looking for the right word to indicate that the victims' families and defendant's family could get in and out of the courthouse undisturbed. So that the judge was buffering because the legal term that he probably would have used would not serve. So yeah, the judge was choosing a different word. So he is being considerate because generally in that term, she speaks, that's exactly what he was going to say. That's exactly what the court was going to say, unmolested by the media, because that, legally speaking, is a word that gets used in different context than in societal context. So I think the judge was like, nope. Undisturbed, unbothered. So yeah, he was picking a different word. Continuing on.
The non-dissemination order, I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to
So that's it.
point out what that
Non-dissemination order
means and what
lifted.
it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to
Ding, 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 ding. The court's preservation order is still in place. Remember, the preservation order is regarding the investigation into the media leaks. And so the preservation order does not change. The non-dissemination order or the gag order is not the same. But the judge is bringing up the investigation into the leaks again. Mary Lou Crafts in the chat said he's still pissed. Oh, fuck yeah, he is. I am not a mind reader, nor am I a psychic on TikTok or any other platform. But I don't know a judge that wouldn't be. That's the kind of shit that will make a judge the most livid. Top of the top is disregarding their orders. And who violated the non-dissemination order can still be investigated even though the non-dissemination order or gag order is being lifted. It doesn't change that it was violated in the past. So Harmon said, so the gag order has been lifted. Yes, the judge just did that. I threw the gavels down because he said it so fast. We highlighted it. Continuing on.
understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed.
Still sealed.
Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright, the request to intervene, because I think it's premature at this point.
The court just denied the motion to unseal. We're going to look at the motion to unseal after this. You can see the judge's demeanor change when he talks about the leak. He's so mad. We're going to talk about the motion to unseal. So not everything is going to get unsealed.
So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest because those are the ones that I have the most
I think that sounds like a good plan, Your Honor.
As to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed.
Do not fucking start sending me public records requests. You're not getting them. Denied. He's like immediately denied, 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 denied. I will unseal the documents. What gets unsealed will go on the public record. Go to the website and get it yourself. Do not send me public records requests. Shit's remaining sealed. That's it. And he said, I'm going to go through the newest documents to the oldest. A lot of what is sealed right now revolves around the investigative IgG or familial DNA. Some of that will remain sealed. The identities of individuals or the names of individuals will likely remain sealed. More information about that process will probably come out, but the names of like, it hit on this, who is a seventh or third cousin of someone or whoever twice removed, those names will probably remain sealed. And I think that's proper. So we will see some things stay sealed and some things not.
And that process is going to take time. And I'm not talking days, and I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera.
Right. The
And so
names.
that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to.
Right.
And so I will be entering
We're gonna
an
talk
order
about it.
in the next week or so, outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court.
We'll get there.
Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
Ms. Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned.
I mean, he
Thank you.
denied
I'll see you
that
next
motion.
week.
Thank
All
you, Your
right.
Honor.
Adjourned. Law nerds, I know there are lots of questions about what the judge said at the end there. Let me stop this video so it doesn't start like auto playing something else and I get distracted. The judge at the end of the hearing indicated that, yes, this Supreme Court ruling indicates that even though somebody has waived their right to appeal, which Brian Kohberger has, it doesn't mean they can't file an appeal. So could Brian Kohberger file an appeal? Yes, he can file an appeal. Alec Murdaugh filed an appeal. I covered that case. Do you remember what happened when Alec Murdaugh filed his appeal? They got the appeal, and then the appellate court said, sir, you waived your right to appeal. You understood all of those waivers. We found that you understood all of those waivers, and you can't appeal because you waived your right. So you can file the appeal, but we are denying your appeal on the grounds that you have waived it. So does it end up being a distinction without a difference and a lot of paperwork? Yes. Can Brian Kohberger try to argue ineffective assistance of counsel and appeal it and say, my attorney didn't properly advise me? Because even if you waive your right of appeal, that is one of very few circumstances where an appeal might go somewhere is ineffective assistance of counsel. That is one of few areas that might go somewhere if you did waive your right to appeal. This is not a case where an ineffective assistance of counsel argument would go anywhere. Why? Because what we have seen is an incredibly thorough defense. Everything we have seen has indicated an incredibly thorough defense. And Brian Kohberger indicated on the record that everything was explained to him, that he understood everything. And his attorney put on the record, yes, I have had enough time to talk to my client. I've had enough time to explain to my client. I've had enough time to do my work. All of that happened during the plea hearing. So could he file something? Sure. Would it go anywhere? No, it wouldn't. So yes, he has the right to file the paperwork. And the court will say, yeah, denied. So it comes down to, you cannot strip away the right for someone to file the paper and said, I didn't understand. I didn't know. My lawyer didn't tell me. And there may be circumstances where a defendant does not understand. That is not the circumstance here. And with Murdaugh, part of what played into it was his educational level. Hey, you are a lawyer. Don't fucking play that with me. I mean, I'm paraphrasing what the court said. In Kohberger's case, his level of education will come into play here. You were a PhD student. Do not tell me that you didn't understand this. There are circumstances where a defendant may not understand for a large variety of reasons. This is not that case. This is not that case. There is no indication that Brian Kohberger doesn't understand what's being said in court, does not understand what his defense attorneys have said to him, and he put on the record very thoroughly that he understood all of his rights, that he waived all of his rights, that he was happy with his attorney. There are a lot of constitutional protections to somebody's rights. Some of those protections, in some circumstances, are more of a formality. In this case, him trying to file an appeal is going to be more of paperwork. I don't see any genuine issue here. Of course, there's always the possibility that there are things that are incredibly unknown to us. But when we talk about the thoroughness of Ann Taylor's representation, Ann Taylor is the definition of doing the most in this defense. There is no indication that Ann Taylor wasn't talking to Brian Kohberger frequently and regularly, wasn't keeping him in the loop. She was filing motions pretty constantly and consistently. I don't think there can be any argument that Ann Taylor was not effective. Ann Taylor went, she's going the distance. Emily, do you have cake stuck in your head? Yes. And Primus, why? Well, Blue Stars at the end of their show have a little bit of Primus sprinkled in there. He's going the distance, and it's stuck in my brain. But I was delighted to hear it. I was like, is that Primus? How many people in these stands know Primus? The parents are all geeked. I don't know if a lot of the performers are geeked. Maybe they are, but the parents are definitely geeked. Ann Taylor did so much. No, that is cake. They have part of Jerry Was a Race Car Driver in the Blue Stars performance. And so the two songs are conflated in my brain from Going the Distance and Primus, Jerry Was a Race Car Driver. So I've got both stuck in my brain, like mishmashed together. So my brain is just No, cake is, yes. My brain is mishmashed of songs. I'm going to start dudding at you in a minute because Emily, how much time have you spent with band music in your head? Too much. Yes. Okay. Bobby S said, oh, my brain heard Emily, do you have cake stuck in your head? So literally until you explained you meant songs. Yes, cake, actual cake. No, I have cake music stuck in my head. And not like Cake by the Ocean. We're going to get very distracted if I keep talking about music because my brain is just like, Helena said, don't you love it when your brain creates a mashup? Yes. All of the mashups on the internet are just like, I don't know, ADHD kibble. I just get so happy. I'm just like, they just mash up songs that make sense in my brain. Getting back to appeal rights, not music that is stuck in my brain. There are, and I don't want to say that there are rights that are formalities because when rights are being violated, they are so important and necessary. When things are not going well, those rights should not be treated as just a paperwork formality. They should have teeth and they should be able to bite back and say, no, you are violating somebody's rights. We have had and I say unfortunate because cases should go properly by law the way they're supposed to go, and we don't always see that. But we have the unfortunate position of being able to juxtapose things that have gone on in the Karen Reed case in Massachusetts and things that are going on in the Kohberger case. And we have seen two incredibly dedicated defense teams for sure in each case. But in the Kohberger case, when the defense has complained of things that the prosecution hasn't done, and you kind of flip it over and take a look, you're like, no, that happened. You've gotten the things you need to get. That's not the case in the Karen Reed case. In the Karen Reed case, every time something happened, I'm like, wait, what? How? What? Wait, what? In the Kohberger case, it's like, no, this got turned over, that got turned over. These things got investigated. The court had a motion on it, but the court went through every single motion. And the defense brought every single motion they could think of. And when the doors closed on all those motions, the defense went to the prosecution and said, how about a plea deal? Will the prosecution ever explain to us why a plea deal? I don't know. Maybe they will, maybe they won't. I don't know if they will. Will we ever hear from the surviving roommates and how they feel about this plea deal? Maybe we will, maybe we won't. I can only imagine they're relieved and that they feel maybe terrible about saying that they feel relieved. Because I don't know if there's any good way for the surviving roommates to talk about this case. Because the internet has been, not y'all are amazing. But parts of the internet have been horrible to them. And so would you want to speak up or would you want to protect yourself? And if that was your friend, family member, kid, you would want them to protect themselves and not speak up. So I don't know if we'll ever see the surviving roommates say that they are relieved. But I'm sure that they are. Because how could you not be? And second guessing themselves. So we will see that sentencing tomorrow. We will see who does impact statements. They have the entire day tomorrow and Thursday set aside for those impact statements. What we learned from the hearing on the 17th that we just went through, the judge removed the gag order, the non-dissemination order, but reminded everyone, hey, that does not change the sealed documents to unsealed. The sealed documents remain sealed. But Judge H indicated that he's going to begin the somewhat slow and long process of reviewing every document that's sealed and unsealing it as much as possible. I think the judge did a good job of setting expectations. Not every judge does this. He did, and I appreciate it. Judge H set the expectation that not everything will be unsealed and not everything will be unsealed quickly. He indicated that the things that will remain sealed are things for the privacy of the victims and things for the privacy of other individuals primarily. Names, birthdays, social security numbers. Remember, in this case, they dumped at least one entire cell phone tower. So it's possible that humans that just live in the area or are visiting friends or were there for parents' weekend or whatever had information in that cell phone tower that might have come up in motions. Should those people's names be disclosed publicly? I don't think so. Is there any public interest in it? No. The defendant has pled. There is no public interest in it. And what good would it accomplish to unseal the names of individuals who happen to be in an area at a time? None. But the downside is that it could create havoc for those individuals. And that is not appropriate. So I expect names will stay sealed. I expect we will see information regarding the victims staying sealed. I expect we will see names, social security numbers, and then family members of the defendant or anyone connected to the defendant through familial DNA, those names staying out, and maybe the type of relation staying out. If it's like third cousin, maybe that part will be in, but not the name of said third cousin. Why did you pick third cousin, Emily? Just because in my brain, that's what made sense. I don't know if that's what it was. It could be a 10th cousin twice removed. I don't know. Emily, how much time do you spend talking about familial DNA? Not much. I don't look at it. It's not part of my purview or what I do now. So those types of things I think will remain sealed. We might see, and I hope that we see information that prosecution and or law enforcement will give more information to the victims' families. What the non-dissemination order being lifted allows for is if there are things the victims' families choose to disclose about their own child, that they can choose to do that or not, because they are no longer withheld from disclosing information if they choose to. But I think it gets to be their choice on what they disclose. And I think those names should stay redacted out of records. I have no problem with that. Sure. Keep the names redacted. But the families are more free now to speak about things they've learned that might not have been public. Law enforcement is now more free to speak about things that might not yet be public. But that doesn't change the fact that there's an ongoing investigation, we are told, regarding who leaked information to the media. I will link below my coverage of that. I am with Judge Hippler on this. Emily, you're a stickler for the rules. Yep. This is why I do not consider myself a part of like reporter or journalist media in that way. Because if somebody came to me, and they haven't, this is an if, hear me. If somebody came to me with information that I was not supposed to have, I would not disclose that information. That's not what I would do. It seemed to me, from what I looked at, Dateline at a minimum had the entire defendant's cell phone dump. That's not appropriate. They shouldn't have had that. So I would not work well within that like investigative reporter world. I am a lawyer. And so my brain defaults to lawyer, which is why I disclose it. Now, do I fall under media protections for the type of work that I do here online? Sure. But I'm not comfortable in the realm of I'm not supposed to have this information. I don't want it. And so when people are like, Emily, do you want to talk to this person in a case? I'm like, what do I always tell you guys? I don't want to talk to anybody till this is done. And even then, I would prefer generally to talk to the lawyers because the lawyers know what they can disclose and what they can't. But the media had what looked like the entire defendant's cell phone dump. They had surveillance video that had only been for police and parties. So who leaked that information needs to be discovered. And it could be anyone with access to that information. And in a case like the Kohberger case, that's a lot of people. It's experts, it's investigators, it's private investigators, it's law enforcement from a bunch of different agencies, it's prosecutors, it's defense attorneys. If the attorneys did it, it's going to be a huge issue. But if anyone subject to the gag order did it, it's a huge issue. Because the media had stuff that was clearly not part of the public that was from the file. And there should be consequences for that. Because it's the type of thing that, for me, could make it more difficult to find a fair and impartial jury, which is not okay, especially if that was the intent. Because if that's the intent, it's fuckery, and somebody should go down for that fuckery. If it was to game the system, that's also fuckery. If it was to cause more anger towards Brian Kohberger so harm happened to him, also fuckery, someone should be responsible for that. If somebody was trying to delay the trial, fuckery. Like, there's no legitimate purpose to leak that information at this point. And this is different than like a whistleblower situation down the road. Don't conflate the two, please. I know you all won't. But a public trial was pending. And that process needed to be allowed to play out. If this had happened after the gag order was lifted, it wouldn't be a problem. There was still a gag order. And court orders have to be respected. And I wonder if we'll see criminal contempt. We could, but I very much want to know what happened. Steph E. Green said, what if it was a private PI that released it? They were gagged too. If they were working with any of the parties, yes, they were also under the court's order. They were also under that order, and they can be in trouble. And then the attorneys that didn't make sure that they didn't give information can be in trouble. Jennifer said, question, Emily, how could the position of the possible leaker affect the consequences they might face? Lawyers have some different rules of ethics that also apply. So there is a court order, but there are also attorney rules of ethics. So the attorneys have a couple different sets of rules they have to follow. Law enforcement also has their own sets of rules they have to follow, because violating a court order could become a potential Brady situation where a law enforcement officer just disregarded what the court said. If they testify in another trial, that might become impeachment because, oh, you just disregarded a court order. We need to ask about that. If they are expert, it might change if the expert gets hired again in the future. And depending on what type of expert the expert is, they might also have a licensing agency and ethics that they are beholden to. So what job they have will change how bad it might be. But it should be bad. There shouldn't be a benefit. And God, if there's a financial benefit, it's even worse. There shouldn't be a benefit to leaking information in a pending public case. It's not appropriate. Now, on the other side of that, on the media side of that, the media is not under the gag order. So the media is not beholden to the court, and the court can't necessarily punish the media. It's not that dissimilar from the situation in Massachusetts with the grand juror that leaked the information. Who gets the information is a completely different circumstance than the person who discloses it that's under the court order to not disclose it. Different circumstance. So, KK asked a great question. Can families get access to sealed documents and evidence even if the public can't? It's their loved ones. They might not get the physical documents, but there is information that they can get that the public might never get. Yes. There are going to be some limits on that, and there might be some limits on what they want. Because things like crime scene photos should always remain sealed, but families should have access to that. However, my concern for the families then is that they make sure that they work with either their attorneys or people who know them to make sure that they have the highest level of digital safety, because people will try to find that. And it's something that in grief people would never think of is, oh, if my email address is attached to a social media, that people might try to hack into my devices to try to find those things. And so I hope that as those things happen, they also take the necessary steps to protect themselves, protect their digital devices, etc. It's a hard thing to even think about, because why would you even think about that? So, Stephanie Hall asks, can the court punish the media who violated the order? The media weren't under the order. The media weren't under the order. The media weren't restrained. The people talking to the media were restrained. So no. The way that courts take action on this, truly, is that they stop allowing media in courts in this way. That's how they punish the media. Other judges say, see what fuckery happened in that case? I don't want that fuckery in my case. And they start restricting access. That's what they do. I don't want to see that happen either. It's terrible. So, to summarize if I didn't summarize already, because I completely lost my train of thought, I've not had enough, I am underslept and undercaffeinated. Judge Hippler removed the gag order at the hearing on the 17th, made clear that the investigation into who leaked documents was ongoing by saying that the preservation order, the don't delete your shit order, the preservation order is still intact, and told the media coalition that their motions regarding unsealing documents are denied at this time as premature, and that the judge will not even start to endeavor to review sealed documents until after the sentencing, which is taking place tomorrow on July 23rd. And that when the court does begin to endeavor unsealing documents, that he will go from the most recent documents to the oldest documents and start unsealing the ones he is most familiar with before he gets back to the documents that Judge was handling, and that it will take a matter of at least months. The judge also set the expectation. If people start sending in public information requests or public record requests, those will be denied. That the court is going to go through the process of unsealing documents, and it is going to take time. And when I said at the beginning of covering this that the door is not going to close on this quickly, or the chapter is not going to close quickly, it's because we're still going to have documents becoming unsealed. And as those documents become unsealed, we are still going to take a look at it. So this case, though tomorrow, maybe Thursday, will be done in the sealing, we are not done. The judge also mentioned that he might let the appellate process run. 30 days from sentencing is what we should see if Brian Kohberger is going to file any type of appeal, because he has the right to file. But he did waive his right to appeal, meaning the appellate court is going to say, no, we're not doing that. Really, the only grounds he could bring up are ineffective assistance of counsel, and this is not the case for that. I would be surprised if we see anything filed, truly. I hope on the court side of things, after sentencing, we are just about done, other than the unsealing of records that have been filed. Other things will remain sealed. The police file, crime scene photos of the victims, those things will remain sealed. But law enforcement can have more candid conversation with the victims' families if they want to know. There are some things they might not want to know. There are some photos they might not want to see. Some people might want to know everything. That's up to each individual, and everyone gets to choose their own journey on that. There are things you can't unsee about a case. But I'm going to continue following the leak information because it is something courts are very concerned about in high-profile cases, and I hope it doesn't limit the access to court in high-profile cases. It's frustrating. We are going to move on to questions in a minute because we have a few documents I want to take a look at. So, and then we will get to it. Let's see. Karen said, I hope we find out who leaked it and get to watch their trial. We'll see what happens. If they just go through the court order, we'll see. Betsy Ross pointed out it was someone who had access to Brian's phone. None of the victims' families had his phone. I don't know if there's controversy over this. I hope there is not. If there is, y'all don't need to tell me. It's fine. The victims' families did not have access to the things that were shared. It was someone who would have had access to the case file. And that would be somebody working with the prosecution or defense. So the victims' families did not have a ton of information. They really didn't. So same with the defense. Virginia asked, could it be someone like Brian Kohberger's parents or sisters? They wouldn't have had that information either. However, if they did have that information, the person who gets in trouble then is whoever gave them that information, which on that case would be somebody from the defense team. And if that's true, then that's a problem. So we will see. I'm not going to speculate on it because we just don't know. Somebody would have had access to all the digital files and the phone dump of Brian Kohberger's phone and the security videos. Elizabeth said, what if it's multiple leaks? Everybody who violated the order can get in trouble for violating the order. It's not like, well, just because one person did it, it clears it. Nope. There is a court order in place. Whoever violated that order and gave out information is the one that's going to get in trouble. Or all of them, if there's more than one person. Yeah, multiple people can get in trouble for a thing. There's no limit on who can get in trouble for violating a gag order. Let's go to the motions and then get to questions. Sound good, law nerds? Okay, I know. All of you just want to talk about Adam Wiley. I see you. I know. Not today. We're Kohbergering today. We're Kohbergering tomorrow. We have a very long day tomorrow. Like a very long day tomorrow. Cub said, what if it's a Fed? They're still under the court order. The court order is still applicable to them. Scary Mac said, can the media be forced to reveal their source? No, they can't. But there are other ways to find that information. Nikki said, I might have missed it, but what would the law be called for the violation? It is violation of a court order. So contempt is generally, it can be contempt or criminal contempt. It just depends. So I don't know. We will see what they decide to do. But we start with the violation of the court order because there might be other things that are an issue. Let us continue. So Tonk said, if a member of the defense team leaked it, does that impact the argument for IAC? I don't think so. I don't think it changes whether counsel properly advised Brian Kohberger or properly did their work, because the defense can bring in private doctors, investigators, and if one of those people leaked it, it doesn't change the defense's advisement of their client. So it does not change that. The court might be mad, but it doesn't change that. So let's get to motions real quick because we have a few. I'm just going to go through the formal court order here on the hearing that we just watched. So let me grab that. It's a very brief order, so this is not, it's a brief. So that's not going to be all that much, but just to round it out, we're going to go to that. Let's add that to the thing. July 17th, 2025. Order vacating revised, amended, non-dissemination order. For the reasons articulated on the record on July 17th hearing in this matter, the motion to be heard as interested parties and the motion to vacate the non-dissemination order is granted. Done. Just done. A few of you have asked, Emily, what if the FBI leaked it? The FBI! That is really not their style. The three-letter agencies tend to like to operate in silence. They move in shadows. So that is not, it would be very, very surprising to me. There are other options that are less surprising to me. That would be one of the more surprising outcomes. Pretty Mama Bear said, wouldn't Dateline have to clear this with legal before releasing the information? Yes, they should. And most media outlets have pretty thorough legal departments. However, Dateline isn't under the court's non-dissemination order. The court order doesn't impact the media outlets. It is the parties to the case that are controlled by the court. So Dateline having access to information that was improperly disclosed doesn't stop them from airing it. The person who shared it with them can get in trouble, but they can't. Hopefully that makes sense. There are balances of rights here. There is an interesting new motion from the prosecution. We have not seen this granted yet. Let me take a look and see if anything new popped up today with regard to this real quick. But this new motion, I think, will be granted tomorrow. So we're going to take a look at the prosecution's new motion for no contact and go through that. So this one should probably get a swoop because this is a new motion. This is not covering anything that was covered just in court. This is the motion to extend the no contact order. This was filed on July 18th. Remember, in Idaho, they put everything on a public website, but the public docket is often a bit behind the filed docket, which can be challenging. Motion to extend no contact orders comes now the state of Idaho through their prosecuting attorney and moves this court for an extension of the no contact orders previously entered herein, preventing defendant from having any contact with the victims pursuant to the Idaho Code 18920. This motion is based on the fact that defendant has now entered guilty pleas to all offenses in the indictment and will be sentenced on July 23rd, 2025. The current no contact order expires on January 5th, 2027. The state respectfully requests that the contact order be extended for an additional 99 years. 99 years. Do not contact them ever, period. I think the court will grant this. I think this will easily be granted. They do not want the defendant writing letters to the victim's family. They do not want him reaching out to victims' families. And this includes the surviving roommates who are victims of the burglary. So this would include the victims' families and the surviving roommates. Now, if the victims' families or surviving roommates want this to not apply to them, they can tell the court, or they can reach out to the court and ask for it to be lifted as to them. I don't know if any of them will want to do that, but they can. Once this motion is granted, the families can ask to modify it if they want to. Dainty said, what if he wants to apologize? Then he can do it in court tomorrow. He has the opportunity. Tanya said, sorry, what did he steal? He didn't steal anything. Burglary involves the breaking into the home to commit a crime. Burglaries don't have to be theft related. Burglary is the act of breaking in to commit a felony. In this case, it was breaking in to commit the murders. So no theft related crimes. But that is not uncommon that when we hear about burglaries, we hear about them in the context of theft crimes. But breaking into a home to do another thing, including murder, is a burglary. So that was charged as well. And he pled guilty to that as well. So even though it's not a theft related crime, it still counts. If anyone wants to amend this, they can be heard by the court. I don't know if they will want to amend this, but it gives them the choice. And I think the choice should be in the hands of the victims and the victims' families. That's where it should be. So then they get to make that choice. I think the court will grant that. If he hasn't already, I think the court will grant that after sentencing, and we'll just see an order saying granted. We won't see much more from that. So let's grab the other motions in this case, which are we did not go over the defense opposition to removing the non-dissemination order. I think we get a little bit more information from the defense in this, so we're going to go over it quickly. We're going to brief the brief briefly, if that works. The Clay Pixie said it will be live for us to watch tomorrow. Yes, we will watch the sentencing together tomorrow. We will. No dumb questions here. Hold on. This one, not a dumb question, Shauna. Do not couch as a dumb question. No, you're all good. Sentencing will be in person. It's fair. I traveled to go see, this story relates, I swear. Well, in my ADHD brain, maybe not. You guys will track because we're honored. While I was traveling for DCI, Chris, who was part of Team Baker and one of my oldest friends, and we were band mates together, was traveling with me. The amount the two of us apologized to each other is ridiculous. I'm like, we have to stop it. We have to stop as we're like bumping into each other. We have to stop apologizing to each other. It's like, oh my God, I'm sorry. No, we have not slept. We went to bed at 2. We got up at 7. We're just like, sorry this, sorry that. We apologize way too much. So I am mindful of it and not apologizing for things that are not mine to apologize for. There is no need for me to apologize for a wall when I run into it because I have no spatial awareness. So we are getting better at not doing it. And on Team Baker meetings, oftentimes we will force someone to say something nice about themselves if they apologize for something that they don't need to apologize for, which makes everyone very uncomfortable. So the constant apologizing, we are so used to just being like, oh my God, sorry. No, it's okay. It is okay. Apologize for things that are yours to apologize for. Oh my God, I didn't respond to your text for 3 weeks. I thought I had responded in my brain. I am sorry for the delay. That is a thing. Like, I regret that I delayed. I feel badly that I delayed. I am sorry. But to just say sorry for existing in the world, we do not need to do. It is okay. We have normalized it so much for a lot of us that we just, especially those of us that are neurospicy, we are so used to just being wrong that we just assume that we're wrong, so we apologize. It's not us. It's often not us. We gaslight ourselves. We are allowed to just do things, but our first response oftentimes is to apologize. So we will continue. Let us move forward. This is the opposition. We'll swoop again. We've got a lot of motions to go through, so it's easy to place hold for me. And I think it makes it easier to put in our timestamps that everyone appreciates so much. We love them. We love the timestamps. Timestamps like chat are bae. This is from July 15th. This was before the last hearing. We did not have a chance to cover it because it did not hit the public docket until after I was done streaming and getting on a plane to go take a look. All right. Redacted. Great. Valkyrie Arts, yes, I get it. Do not. It is not you. But being aware is helpful. But I get that. Opposition to the motion to vacate non-dissemination order. This is from Brian Kohberger through his attorneys. Kohberger's request regarding the order is based on 1, the language of the order that had not previously been challenged by the media. 2, the ongoing publicity regarding the case and threats to Mr. Kohberger's safety. 3, redacted, and the hold order for all witnesses issued by this court. That's the leak. Number 3 is about the leak. Part of why the court brought it up is because of the leak. The language of the revised amended non-dissemination order issued on June 23rd, 2023 specifically ran through sentencing. In response to significant litigation and an Idaho Supreme Court ruling, footnote 1, on the issue in this case, the court issued a revised amended non-dissemination order on June 23rd, 2023. By its terms, the order was to remain in full force and effect until the conclusion of the trial and any sentencing proceedings that may follow, unless ordered by this court. Which means the court at any time can revise the order, which they did. So, negative, Ghostwriter, the pattern is full. After this order was issued, the interested parties raised no further objections to the revised order. Right, they objected now because the situation is that he pled. Here's the difference. If Brian Kohberger had gone through trial and Brian Kohberger had gone through a penalty phase trial, there would still be a jury in place until they came back with a verdict. And if they went through a penalty phase trial, the verdict would either be life fixed or the death penalty, one of the two. So his being sentenced on that would come after a jury finding, but there would still be a jury. They can't write this order to just go through guilt, right? Or innocence. They can't write it to just go through verdict because there are technically two verdicts in a DP case. So the court wrote the order to cover through the second phase of trial. Otherwise, the media would be like, oh, there's a verdict. There's still a fucking jury though. Oh, but there's a verdict. The court wrote this in the way that they needed to. The court can revise it. The court has done so. This argument does not really land, but I guess when you have nothing else to argue, you argue the language of the order. The motion filed by the media to vacate the revised order asserts that once a guilty plea is entered, that his right to a fair trial under the Sixth Amendment is extinguished. There's no trial. Because there's no trial. Because there's no trial. Because there's no trial. The defense says what the media fails to recognize is that Mr. Kohberger retains his rights to a fair sentence proceeding guaranteed under the 14th Amendment. The judge is not going to be swayed by what the media says. The judge has seen everything in this case. The judge has seen everything that's sealed. So the judge isn't the issue. Right? The judge knows. And it's an agreed upon disposition of the maximum sentence that the judge can give. So we're done with that. The ongoing publicity in the case threatens Mr. Kohberger's safety. And I know some of you will have very strong feelings about Mr. Kohberger's safety. The reality of the circumstance is the state is obligated to keep him safe while he is in their custody. They are obligated to make sure that he is not harmed by members of the public. He is not harmed while in custody. And if they fail to do that, the lawsuits can be substantial. So while many might feel like, I don't give a shit about Brian Kohberger's safety, your feelings are valid. But the state has an obligation to keep him safe while in their custody. That is their obligation under the law. They cannot just allow him to be harmed. And if they do, it's going to cost the taxpayers of Idaho quite a substantial amount of money because of the civil lawsuits. So I would like the public in Idaho to not have to bear that burden. And I understand the feelings on this. The defense says, as set forth above in Section 1, the amount of publicity coming before sentencing, even with the revised order in place, is massive. Further release would only serve to gin up the language of this. Just would only serve to gin up the anger and violent rhetoric already at a fever pitch. It's a strange phrasing, and I've seen a lot of frustration. I have not seen that. To be fair, I don't see everything on the internet. I am not online nearly as much as some, but I have seen frustration expressed about this plea deal. I have not seen, but that does not mean it exists. I have not seen lots of calls for harm to Kohberger. I've seen many say, well, May he have the fate that he deserves. I have seen people just saying, good luck with that. But the defense would be much more aware of this than I would be. Also, for those of you who are like, gin up belongs with shank of the evening. Yes, we're leaning back into languaging popular in the 20s. The defense argues that we read that sentence. The further release would cause the rattling of the hornet's nest of violent rhetoric. This court is well aware of the threats posed not only to Mr. Kohberger, but to his family and to the court staff. Unfortunately, I don't doubt any of what the defense is saying here, and I'm sure the court staff is not thrilled with having to navigate the amount of online fuckery bullshit. Though if there are threats made to the court, that is something that you can see the feds involved in investigating in the background. That wouldn't be disclosed that they were investigating that. But if people are making threats to the court through email or phone, that's going to be federal because it's going over the wires. So threatening court staff also tends to have higher sentences than like a traditional criminal threats type of case. So if people are doing that, they might find themselves charged for that. Also, if threats are coming in regarding Mr. Kohberger, the court staff is going to have to deal with that. And I'm sure we will see a massive amount of law enforcement for the sentencing. And I'm sure part of the reason, just on a side note, part of the reason they are doing the sentencing, the dates they are doing them, the court explained at the plea hearing, is that the courthouse was essentially shut to all other business, which is an incredible feat because this is one of the biggest courthouses in the state, is my understanding. The courthouse is shut to other business, or most other business, on Wednesday and Thursday. I imagine the judges will have all their hearings, if they have hearings going on, via Zoom, so the attorneys aren't coming in. Because they had anticipated those days, they would be bringing in massive panels of jurors. So no other jury trials are going to be going on those days. So the other courts can run remotely, so that court can really lock down the security for just this hearing. So there's not going to be a lot of opportunity for fuckery because the court is going to be pretty locked down, and it's streaming. We will get to see it live. There's no need to be there in person. I think it's more important to allow those immediately impacted by the case to be there in person if they want to be. The rest of us can see it from here, and that will be fine for us. So the defense is saying that the court is well aware of threats posed to Kohberger, his family, and court staff. That shouldn't be happening. I don't doubt that it is. I imagine that the DA's office has also been flooded with emails and what have you because people are not happy with this plea. At this point, the press have access to every witness who is not an agent of either party. As the court noted in its denial of the motion to vacate the amended non-dissemination order in 2023, the media is not being restrained, only the parties are restrained. And those restraints are reasonable. This goes back to why I said earlier, the media is not going to get in trouble for publishing the leaked information. It is the person who leaked it that was restrained that is going to have an issue. But there is no, there are no legal sites here. There are links to YouTube videos, Peacock TV to the issue, and then the new James Patterson book that's been released. Those are the links are to media. There's no law here. Court security resources were at maximum capacity on July 2nd, 2025. The sentencing hearing scheduled for 2 days promises to be even more taxing on those resources. They can bring in overtime. They can do it. I'm sure they've done it before. They've had other high-profile cases in this courthouse. The sentencing hearing will be more taxing. Lifting the non-dissemination order now is likely to change the atmosphere near the courthouse and may well push security needs beyond capacity. These are realistic concerns, but they are not a legal ground to keep the non-dissemination order in place. Courts can't just say it's more convenient for us to keep it in order. We are dealing with constitutional rights. So the court can't say, well, it would be more convenient for us if you would just not The court was right when he said in that hearing on the 17th, the media is going to talk about this case one way or the other. So these concerns, though realistic, aren't going to change. The court has issued a records hold order. I went through that records hold order. We will link it below. After the release of the May 9th, 2025 Dateline special on this case, the court issued a hold order. This is a good question. I'm going to hold a couple of these till we get to Q&A. After release of the May 9th, 2025 Dateline special on this case, the court issued the hold order on both parties. I covered that. In its response to the media motion, the state now withdraws its request for the non-dissemination order to be continued until sentencing. The state cites further reflection and continues that. The further reflection is that there's no legal grounds. There are no legal grounds for it. The state cites further reflection. Your Honor, upon further reflection, there is no legal basis for us to continue to object. So we're going to stop. The state cites, quote, out of respect for the integrity of the judicial process and the privacy of the victims and their families as they consider their rights to provide victim impact statements at sentencing, the prosecution team, footnote 5, does not intend to make any public statements about this case until after sentencing is concluded. So we may see the prosecution say something. Footnote 5. From the language, who is, quote, promising not to speak to the press is vague. Does this mean the attorneys, staff members of the prosecutor's office, or all of the 150 law enforcement officers involved in this investigation? On July 2nd, an entire row in the courtroom gallery was occupied by law enforcement who were watching the proceedings. Will a third of the courtroom now be allocated to law enforcement, free to provide media interviews as they enter and exit the courthouse? Maybe. And they can. Have we seen any media interviews from law enforcement before sentencing? Because I haven't seen any. And normally, if there was one, like my DMs and emails would be full of, girl, did you see this? Emily, how did you know that Adam Lally had been in court yesterday? Because y'all told me. I just haven't had a chance to get to it. So, yeah, they're just like, ugh. The cops might talk. What are they going to say? He's guilty? Okay, he already said that in court. What is law enforcement going to say? This is one of the most horrific cases that they've ever seen. We know that. What shocking thing is the media going to say, or is law enforcement going to say? This is depraved. It's appalling. It's horrific. It's sad. What are they going to say that we don't already know at this point? We have all this video. Okay, we know that. Sure. I mean, okay. The defense goes on to say that the state's promise rings hollow given the previous leaks from sources, quote, close to law enforcement. They're just like, zing. Okay. The defense is again pointing the finger back at the prosecution side of the table. However, anyone on the defense team also had access to law enforcement and all the law enforcement documents. But the defense is salty. Look, the defense has done everything they can to defend their client. But he admitted to these murders. He admitted to doing it with pre-planning. He admitted breaking into the house for the purpose of committing murder. Okay. Conclusion. Kohberger requests the court deny the media request to vacate the revised order ahead of sentencing. This entire motion is vibes and complaints. There is not a scrap of law that supports this. In order to maintain the integrity of the process and the security and safety of all the parties involved, including the families, court staff, and attorneys, The revised order shall remain in effect. Look, here's what I will say. The concerns for safety are valid. In the defense's motion, they cite circumstance, not law. Concern of safety. Those safety concerns are valid. But this is not the way that they are handled. The non-dissemination order does not change those concerns. Should people be threatening attorneys in this case? 100% no, not ever, no. The defense attorneys in this case did their job. People might not like the way they did their job, but you don't threaten to harm someone because you don't like the way they're doing their job. Their job is to zealously represent their client. They did that. The prosecutor's job is different. Their job is to represent the people of the state of Idaho and their best interest in seeking justice in this case. There are many who feel they didn't do that. If you live in Idaho and you do not like the way the prosecutor's office handled this, you can vote for a new head prosecutor. I think the current one is retiring. Vote in a new elected DA and tell them you want them to pursue more strict punishments. Sure, vote them out. Raise money for their opponents. Do all of those things. But physical threats to people's safety is fuckery. And you know what it doesn't do? It doesn't change people's minds. Threatening someone because they're doing their job makes them more generally, especially with attorneys, set in their ways. It does not actually change them. And they didn't do anything, from what I can see, wrong. They did their job. But the elected DA for Latah is Bill Thompson, the Santa DA. I wouldn't be surprised. I don't know when their elections are, but I wouldn't be surprised if we don't see him run for DA again. I think he was getting ready to retire prior to this case. And it is more rare that you see the elected DA taking a case and in court. We saw it in the Darrell Brooks case. The elected DA was in court trying the case. I have a tremendous amount of respect for that. There are lots of elected officials and elected DAs that do not go to court any longer. There are some large jurisdictions where it's just not possible. But when the elected DA is a trial deputy and is like, this is my case, this is my office, this is my decision, and they stand by it, I respect that. There is a lot of you are pointing out that there are elections coming up in Norfolk for the DA. Yes, I think we will see a vigorous election for the DA in Norfolk. So, though the defense concerns about safety are valid, those concerns are best addressed through law enforcement. And if they need to call in law enforcement from elsewhere, they can. They can call in extra help. And I'm sure that they will. That's tomorrow. So, I think there was one more I wanted to look at. I don't, but I'm not 100% sure. The unsealing of records. Yes. That is what I had forgotten. So let's take a look real quick at the request to unseal records, and then we will move on to questions. Yes. All right. Where did it go? Where did the swoop go? I lost my swoop. We've had lots of swoops today because we've had lots of motions today. Stop summarizing my documents, Google. I don't need it. Motion to be heard as interested parties and motion to unseal records. This is time-stamped July 14th. This was before that last hearing, after I had finished streaming. This is the Media Coalition. ABC, CNN, local media, Idaho Press Club, Moscow Pullman Daily, et cetera. July 2nd, 2025, Brian Kohberger pled guilty to the murders of 4 University of Idaho students and to 1 count of burglary. Kohberger's plea sharply changed the Sixth Amendment fair trial, First Amendment balance in this case, and has rendered the primary justification for the sealing of records in this case moot. Indeed, the infringement on the First Amendment rights of the media and public through the voluminous sealing of records in this case is no longer justifiable, nor does it comport with Idaho Court Administrative Rule 32. Rule 32 expressly allows for a non-party whose rights are affected by or otherwise have a right to access information obtained in a court file may move to unseal records in a case file. Accordingly, a coalition of media organizations as interested parties respectfully move the court for leave to file their motion to unseal records. The Media Coalition further requests the opportunity to present oral argument on this issue at the court's earliest available opening, footnote 2. This motion is supported by the accompanying memorandum and declaration of Rebecca Boone in support of the motion to be heard to unseal, footnote 2 says, there is currently a hearing set for another Media Coalition motion Thursday, July 17th. The Media Coalition recognizes that this is a different motion, even though it involves overlapping issues and will likely require its own separate hearing. If the court deems it proper, however, the Media Coalition will be prepared to discuss this motion. And what the court said was no. The court said no. Nope. It's premature. We're not doing this now. And the court said, I will be on my own unsealing records as appropriate. I think we will see more a little bit more media fighting over public records and documents. So I do not think we will be done with hearing about this case because the unsealing is going to come out in bits and pieces over months. More facts will be learned about this case in the months to come. If you are curious about things as they get unsealed, because I know that you come here for the facts, and then we can talk about all the fuckery to the side of it, let me know. I will keep asking you guys and checking in if you want to hear from the unsealed documents as they happen. I follow cases long after they are traditionally closed, because even after there is a plea or a conviction, we are not at the end of a given case. So we tend to follow them until we're at the end. So I will keep checking in with you and ask, and I will probably, as things get unsealed, group those things together and then summarize them as we go. But we're going to take, after sentencing, a little bit of a step back from this case. Immediately after sentencing, this is what I anticipate. Well, I will also be traveling. We're almost done with that. But immediately after sentencing, I think we may see some more interviews and some more information about the case. But then hopefully there will be a little bit of a period of time where there is a little bit of a lull and the media will move on to something else. And then something will get unsealed and all attention will be back on this case. So I will be keeping an eye on it, but it will come grouped together. Priya said, Emily traveling, that's new. It's a busy time of summer. Between now and finals at Lucas Oil, it will be busy. So I think the best thing to do is get to questions because there's a lot of questions. I think there's a lot of uncertainty about what's going to happen tomorrow. We can talk about it and answer your question. I think that is the best option. Again, for those of you asking about Massachusetts, we will get back there. I promise. We will fly back to Massachusetts after we are done with Idaho. That's what we are going to finish up this week. So I will be at finals in Indy. So I will be at Lucas Oil for finals. Let's get to questions, shall we? You have questions, I have questions, we have questions. Sam said, this is a great question. Sam and Trayers in the chat asked, are the documents unsealed newest to oldest or vice versa? The court said in the hearing on the 17th that they would be newest to oldest because Judge H is going to review the things that he sealed himself. And then he has to go back and review the things that Judge did, which will take more time and brain power. So it will go that way. My kid's personal Uber driver said DCI talk. It was, I was at the San Antonio show. The Cavs were amazing. But can we talk about Boston's mellow feature? We can talk about Boston nonstop. Also, if you guys ever see me out and about, please come up and say hi. It's delightful to see you. It was also very funny to see the younger, there are tons of bands that go to watch these who are still in high school and what have you, to see them very confused. Like, why are all the adults like, oh my God, can I come say hi? What? Who is she? We don't understand. To all the law nerds I ran into in San Antonio and I'll tell you guys a quick story. In San Antonio, in Houston, it was great to see you. I am very sweaty in all of our pictures, and I am sorry for being very sweaty in all of our pictures. I was melting. It was so hot. Cavaliers were amazing. Boston is having their year. Boston is having their year. Boston needs their year. Like, they totally need it. Get it, Boston. Boston is having their years. I'm sorry, Bluecoats. They just are. And it's a great show. It's an absolutely fantastic show. I think Boom is probably going to score very high and is going to be fantastic. It was also really nice to see, for me as like parent, to see my kid in his element and see members of other corps coming up and talking to him, seeing him talk to friends that he has done marching band with, has done winter guard with, and getting to see him interact in his space. It was just a really fun event. The San Antonio's event is amazing. FJM, who does DCI uniforms, hosted that event. It was just spectacular. I had a chance to sit down and chat with Flow Marching. You will see more of that soon. EDBX marching. I love it. It really is one of my happy places. You guys know that, with live music. And there are times I need a space where my cup is refilled too. And this is one of those spaces for me. And I really often just A, want to see my kiddo, and B, need the cup being refilled. So even though it is not relaxing, we are traveling, it is not relaxing, it does absolutely fill up my heart. And that is something that we all need in our life. So I think that Boston's Mellow feature is amazing. The shows this year are just great. I love it. Allison asked, and I am a band enthusiast. The Cavaliers uniforms, I swear they used to wear hats with feathers. Am I misremembering? Allison, you are not misremembering. The drum majors come out onto the field at the beginning of the show. This isn't always aired, but the band members come out onto the field at the beginning before they proceed onto the field. And the three drum majors have their traditional Cavaliers capes and their hats with the feather. So when you see is your corps ready, and you see the drum majors do their entire routine of is your corps ready, they have their hats on with the feather, they take them off and place them down, and then proceed to begin their show. So they do wear them out for their procession on and off the field, but they do not have them as part of their show uniform. So their salute is pretty badass though. Look, their retreat is badass. They are one of the few corps that has a formal retreat anymore. They have a formal retreat with their drums and with their drum majors and with their captains. So they have a different name for their captains that I'm blanking on at the moment, but they have a formal retreat. If you ever see them retreating the timpanis, take a look at the timpanis being taken off stage. They have a Cavalier standing with the timpanis in full Cavalier form. Absolutely fantastic. So they have a full retreat off the field, and it is there is a energy to the Cavaliers this year that is really special and fun to watch. I love their show. The Boston show, they have been cleaning it, and it has just been ticking up. So good. So yes, they do have hats with feathers. It is not part of their uniform on the field, but it is part of their corps. So when you see finals, you should see the salute aired, and you will see the hats with the feathers. They're badass. It's badass. So it's fantastic. Let's see. EDB, what is with the horse? I shared it on Instagram. The Cavaliers shared it on their show. Sam said it's a very Cavalier show. It feels like the Cavaliers have really gone a long way to to regain and re-embrace their legacy. It feels like a nod to their history and tradition, and there's a ton of energy around it. I love it. The style is right, and I'm looking forward to seeing the next couple years. But the horse running into practice, first of all, the horse, I have no idea how the horse ended up at their practice field. I think they were at a high school. They might have been at a college. Honestly, it's Texas. I cannot tell because some of the high schools are as big as some of the colleges I'm familiar with because it's Texas and I just can't tell. So a horse ran into practice and all of the core members that were going onto the field holding their instrument and holding a water bottle were like, what do I do with a horse? And one of the core members recorded it, but you could see the I don't know what to do with this horse. You could see the discomfort. I don't know what to do with this horse. The horse is on the field, and it was a horse just no rope, just in his not bridle, but his normal just words are escaping me. Emily, you have forgotten the words. Halter, thank you. I have forgotten the words. And so I had seen a few Instagram comments that were like, why didn't anyone grab the horse? I'm like, not every, first of all, the performers in the Cavaliers are from all over the country and all over the world. If they have never interacted with a horse, do not go grab a horse if you have no idea what you're doing. So it was a horse that was maybe local, but there was no way for the horse for them to grab the horse. And their hands are full of instrument and water. Yeah, I don't know. People were like, somebody needs to grab the horse. No, you don't want a 17-year-old that has never been around horses to just try to grab a horse. They're going to end up getting injured or scaring the shit out of the horse and everyone else. It's just going to make it worse. I don't know what happened with the horse. The horse left the field and went back their direction. I'm sure someone in the neighborhood got the horse back to where they went. So it looked like the horse had gotten out of their yard. Maybe they just wanted to check out what was going on with the drums. It's a good show. Hornless unicorn. No, we're not in Tennessee. It was not a zebra. It was a lovely horse. Beautiful horse, but no, not a zebra. So for everyone who's like, Emily, what are you talking? I'll just show you. Is it easier if I just show you? But yeah, a horse that is kind of freaked out and doesn't want to be where it is shouldn't just be grabbed by somebody that doesn't know what to do with horses. So I think the horse just wanted to see what the drumline was up to. Or at least that was my excuse in high school when it's like, what are you doing? Nothing. Why are you around the drumline? Well, why wouldn't you be? Why wouldn't you be? I think the horse was just ready for some paradiddles. All right, why won't this type? Come on, keyboard. Emily, do you have a link to this yet? No. But some of the performers did look a little nervous about the horse. So I think the horse was just trying to find the source of the noise. All right, let me log in so I can show you guys this. And we'll take a look. And then we'll get to the rest of the questions about things that are more serious. But we can take a minute for band things. Because why not? And yes, I know there was a difference between DCI and band, but also our international crew is like, what? But I can show you guys a few clips. Let's see. Where it was in their stories. Let me see if I can find it real quick. Because if it's already come out of stories, I'm going to have to go find where it was. Let me see if it's still in my story. No, nope. Because somebody, I think, posted it as a reel. Let me go see if it's in my stories still and didn't time out. Because it might have. And that will, no, I don't want to do that. I think it did time out. Hold on. Now I got to go find where it got posted. Give me 30 seconds. Streaming is dynamic, especially when I'm trying to find things that I hadn't found before. And then later, we can, at some point, talk about Coldplay unless y'all are already tired. But at some point we can talk about Coldplay. The story with the horse is gone. I do not see it. A horse showed up at practice. It was in stories. Let me see if I can find it real quick this way, because I'm sure it was a reel. Did they post it to their page? Thank you, chat. You guys are the best. I was looking in stories. That is my phone binging. Oh, that's a bummer. Thank you, chat. You guys are the best. Here we go. Now we have found it. For everyone who saw this video and tagged me in it, you guys are the best. Thank you. I did see it. Somebody on the Cavaliers social media team is going to be like, okay, but who the fuck is Emily D. Baker? And why do they keep tagging her? Don't worry, they'll figure it out eventually. It's fine. It's fine. Attention. If you're, wait, where did it go? If your horse is missing, it might be a Cavaliers rehearsal. The discomfort on some of the performers' faces when they are just like, no. They are not happy. But yeah, the horse walked into practice. It looks to me like the horse wanted to find out where the drums were. I always want to know where the drums are. And then the horse is like, okay. The speed that this performer is running away with, the performer is like, get me out immediately. And then the horse goes back out the other direction.
Okay, see ya.
Back through the gate he came in through. Look, the horse found the source of the noise, said, all right, and is like, let's go.
Hey, dude. Horse stumble.
Horse stumble is funny. Right. Horse is like, sounding good, y'all. Sounding good. Beautiful horse. That's a horse that's curious. However, half the comment section is like, horse has its feet out of time. Horse has its feet out of time.
Hey, dude. Oh, horse.
Yep, and then took back off.
Okay, see ya.
The comments are hilarious. By the way, to everyone who tagged me, thank you. The comments are hilarious. The Casper Troopers from Wyoming are like, there you are. We've been looking everywhere. The Blue Devils were like post of the year. W Blue Devils. Surprise Colts appearance at the rehearsal. Colts are a different DCI troop. And so then it gets into very nerdy DCI lore. Crown 2007 called, they want their performer back. The visual tech is going to be using the horse as an example of how high them knees need to be. You guys, by the way, the comments are fantastic. But yes, the horse was like, I saw what I needed to see. I'm out. Exactly. So horse was just like, let's go. Morgan said, did Travis pick the Cavaliers? Cavaliers were the core Travis wanted to march with. From the first time he saw them perform, he was like, this is the core I want to be a part of. So yes, he did. Y'all are Cavaliers. Cavaliers ride horses. Come on, guys. Lying awake. No one is going to say rehearsal. In fact, many did. Many did say rehearsal in the comments down below. But yes, horse showed up at practice. What I do appreciate is how cheeky the different cores are in interacting with one another. The thing I have not seen yet on the Cavaliers page is sharing their trip to Buc-ee's. I've seen a bunch of the other cores share their trip to Buc-ee's. I'm waiting to see the trip to Buc-ee's because they should have just had Buc-ee's. And yes, in Texas, they got the In-N-Out truck, which is fantastic. Never have you seen a group of gentlemen more happy than the In-N-Out truck for dinner because A, food crew doesn't have to food crew, B, delicious. So yeah, In-N-Out truck, go Cavaliers. I don't know if they have a picture. Somebody was asking about the hats. I don't know if they have any video of here is parade with the hats on for parade, but I don't know if they have, nope, that's their encore. I don't know if they have any videos of their salute on their site. There's T. Hi, buddy. So this was them getting ready for rehearsals, getting ready for a show, which I love. The black and white is so good. It's so good. Also, the Lawnards. It's the Lawnards. The Lawnards were here. The Lawnards have arrived. The Lawnards are seen. So for everybody asking about In-N-Out, yes, In-N-Out is coming to Middle Tennessee. I have seen that. So I don't think there is video of their salute. I don't know if the core page, the guard page would have it. I don't think they would, but I'll find one. If I find one, I'll share it with you guys. So, T loves seeing the Purple Hearts. T was like, yay. In-N-Out is expanding to the East Coast. She speaks. That's what I've been told. All the way out to the East Coast. They were putting a headquarters here in Middle Tennessee that was going to be their East Coast headquarters. And then I think it's becoming their global headquarters. Hornless Unicorn said a group of DCI descending on a Buc-ee's sounds like chaos. See that and go to the Flying J. They're at the Flying J quite a lot, but yes, the stop at Buc-ee's is a tradition for most corps. And some of the corps, especially the West Coast corps, I mean, the corps, you don't necessarily march in a corps that correlates with where you live, but the corps are going to have performers that have never been to a Buc-ee's before, and that's a pretty incredible thing. So the corps stopping at Buc-ee's is a tradition, and you will see if you are in the lot for anything that there are just corps members running around in Buc-ee's everything. Buc-ee's booty shorts, Buc-ee's boxers, Buc-ee's pajama bottoms, Buc-ee's, well, not this time of summer, but the Buc-ee's zip up dress, all the things. It is a whole thing. And so for performers who live where there are no Buc-ee's, the stop at Buc-ee's for the first time, can you imagine being with like 150 plus of your friends and they are like, welcome to Buc-ee's. And when they stop, they're going to have like an hour plus at Buc-ee's. Welcome to Buc-ee's. And then they end up with all the Buc-ee's merch and it becomes part of their summer. So I love the core traditions. Love the Buc-ee's, not the LaFufu. I have my Buc-ee's La Buc-ee. It is on my bag. My La Buc-ee is on my bag on my desk because I thought it was hilarious. The La Buc-ee. The La Buc-ee is on the bag. I shared it on social. This is it. This is what we're doing. The La Buc-ee on the bag. And my favorite snack at the moment from Buc-ee's is not even a Buc-ee's themed snack. Where'd it go? Where are they? Oh, where did I put them? They fell over. These. The Willy Wallaby Sourageous drops. They are licorice with a sour candy coating. They are so good. So good. Anyway, these are amazing. We have lots of different Buc-ee snacks, but these are one of my favorites at the moment, even though they are not Buc-ee branded. So everybody's like, no, beaver nuggets. They are actually sour. For everyone outside of the US, Buc-ee's is a massive convenience store / gas station / restaurant. Like they make their own tortillas and stuff. It's so good. Will Buc-ee's still sell Texas merch if they are open in another state? Buc-ee's has, in the Tennessee Buc-ee's I've been to, a lot of Tennessee themed things. In the Buc-ee's I have been to in Kentucky, it has the Kentucky location. They still have some Texas themed things, but they tend to also modify to location. So it's very cool. It's snacks for days. It's homemade sandwiches. It is, fresh meats on the board. It is everything. I don't know how to describe a Buc-ee's. It's everything. And then if you can merchandise it, it's merchandised. And they're all of the snacks, all of the food, all of the clean bathrooms, and the bathrooms run kind of like they are the smartest. Theme parks should learn from Buc-ee's. The bathrooms are all lined along the outside in like a U shape, and then the sinks are all down the middle, and then the bathrooms all have a light, and the light is either green or red. So you can see if a bathroom is available. The bathrooms are so good. So, you don't have to walk around and look and see if there's a locked door. It's just, it lights up like you're at a parking garage. Green light means go. It's so easy. So there's no backup to find the bathroom, and the bathrooms are so fucking clean. They are always clean. There are a ton of them. Every stadium in the world could learn from how Buc-ee's runs their bathrooms. Glorious. Glorious. Love it. So if you see a Buc-ee's, the bathrooms will always be clean. They are great and easy. And the merch is fun and cheeky. And they make fudge, they make fresh sandwiches, they have every kind of beef jerky imaginable. It's all the things. But you just have to experience it, and it can be overwhelming. Buc-ee's is big, like Costco big. Like when the international crew is like, everything's bigger in Texas, Buc-ee's is the pinnacle star of that. Everything is bigger in Texas. They went yes and. And it is, the food is big. The cinnamon rolls are big. The cinnamon rolls are all the things. All right. So, is Buc-ee's fudge better than fudge from Uranus? Lindsay, you know what? I think we need to do a fudge comparison. I think we need to do a taste test, because honestly, I would need to do them side by side because I don't remember well. So we're going to need to do a side by side. Let us continue to all of your questions, not about core, though I love talking about core, and I will sidetrack myself to do nothing but watch shows. For those of you that are like, okay, give me 30 seconds. TXLB said, whole different world than 7-Eleven. Yes, it's like plus and. Let me see if there's a little clip of, were we just talking about Troopers? We were just talking about Troopers. Hold on. Let me show you this little clip of, this is Troopers salute. Let's play this real quick so you guys can see what I'm talking about with the salute. This is the Troopers salute from their drum major. So this is the Troopers drum major. Again, when we were talking about the horse, when they were making jokes about whether the troopers were looking for their horse, this is why. But this is their drum major's salute. So even though not a Cavalier salute, it is the badass Troopers salute. Right? Let's go. I love that. Fantastic salute. So good. All right. So Troopers, when we were talking about salutes, that is their salute. They leave their hats on. So she's just so great. I love it. I love it. The judges are all the way up at the top. So that is from Flow Marching's social. Let me see if there are any clips of the ending of the Cavaliers show real quick. They've got a ton of clips up on their social from San Antonio. Let me see if they added any. There is so much on social. That's Blue Stars. That's Blue Devils. That's Blue Coats. Something other than blue. We're like Crown, there's Phantom, there's Cavaliers. Okay. So for those of you that are like, wait, I came in for law and we are now talking about marching band. Yes, DCI. Yes, we are talking about core. It is the Olympics of marching band, the major league of marching band, if you will. This is the end of the Cavaliers show from, let's see. I think this is the tour preview. This is from Muncie. So this is the very, very beginning of tour. which is why it's still daylight. So this is the end of show. They cleaned that a little bit. So this is their very end of the show. And yes, they are all standing on top of the props. I love the end of this show. But yes, they're all standing atop the props. It's wild watching back at the beginning of the season because this show has grown so much. Everybody's have, but it's cool to see and look back. This is the beginning. All right, let us continue. Questions about law. So for all of you that are like, marching band, it is a whole thing. So let's get back to your questions. They make it look easy, but it is difficult, and they do not get a lot of sleep. I think this is the time of the season when the cores are like getting into housing sites at like 7 a.m. after being on the road all night. And then it's like, okay, bedtime is 7:15 a.m. And then you get up and practice all the things. All the things. It's always a nice palate cleanser talking about DCI because law can be so heavy. Yes, and we haven't gotten to do a food court. We are desperately in need of one, and we'll do a more DCI. We'll do a more DCI focused, maybe members only, so we can talk about it. Rock and roll is like, could David Yannetti run for DA asking for a friend? I mean, there's nothing that would stop David Yannetti from running for DA other than possibly a pay cut, because there would probably be a pay cut involved. But there's anyone who is a licensed attorney can run for district attorney. I don't know if they would want to. I mean, I don't know why Yannetti would want to do that, because it's that's a lot of work. That's a lot of work. Tracy said, and we love the marching band interludes. And I know that there's plenty that come into the show and are like, wait, what are we talking about? It's that. So for all the law nerds that are here and everyone who gifted memberships, thank you. It's good to see you guys. It's always good to see the member chats. Even if I don't pull them up, I always read them in the back end. We need to do test members only for some of our software. So we will do that. Let's see. Melissa said, I have 4 former students on 3 different cores that were in Texas this last weekend. So much fun. Yeah, everyone descended on San Antonio, and it's really fun to see not just how small the band world can be, but how interconnected and fun it can be. It's really just fantastic. It really is just fantastic. Mindy asked earlier if the victim statements are tomorrow. Yes. Tomorrow for the Brian Kohberger sentencing, the impact statements are tomorrow from those that choose to make them or not. The court can also be submitted impact statements. So if families choose, and I think Ethan Chapin's family said that he wasn't going to be there. I think the Gonsalves parent father said he wasn't going to be there. I don't know if other family members will. I think possibly siblings may be there, but they can also submit a written statement to the judge for the judge to consider for sentencing. The sentencing's not going to change. This is a part of the process that is, I think, needed for those who want to be heard by the court, but the court sentencing is going to be a fixed life sentence. So what is said tomorrow is not going to change it being a fixed life sentence. But the court gets to hear, and the DA gets to hear, and the defense and the defendant gets to hear, and really the world in a case like this gets to hear how this case impacted people, and is really the only opportunity that the victims' families in this process get to be heard about what is lost for them and the impact of these crimes. Because from the time somebody is arrested through the time somebody is convicted, most of the focus of the process is on the person who's been arrested, the defendant. Did the defendant do the thing they're being charged with? That's where most of the focus of the case is. Are their rights being protected? Did they do it? What is the evidence that shows they did it? What will the eventual outcome of the case be? So for the victims' side of the process, and whether it is victims or victims' families, for the victim side of the process, sentencing statements are really the only time that they are heard by the court. They should be heard by the district attorneys within the process, and they will speak to law enforcement sometimes, but it's the only time the court hears from them. So that is tomorrow. Soko said, is it common for victims to have to submit their impact statements beforehand so the attorneys can review them and ask for certain things to be stricken? It depends on the practice of the court. It just depends on the practice of the court. It is done in a lot of courts. It is not done in some courts. So it just depends. But there are some boundaries of what can be said. And there are times that courts ask for no name calling, no threats, things like that. But it really, really depends on the jurisdiction. And that can depend on the judge as well. Sometimes the judge will want that. Sometimes they won't. Carrie said, hey, DB, what's the next live trial on the docket? It depends. It just depends on if Adelson goes forward on time. So we'll see if Adelson goes forward on time. But if Adelson goes forward on time, that will likely be the next trial. Corey Richens won't go to trial till February. And Corey Richens has a hearing in August, but I don't think it will be streamed. Let us continue. Daydream said there's some songs that I just start tearing up barely even a second into the song. Yep. 100%. 100%. So let's see. Barry SD asked earlier when we were talking about the leak, is it possible it was one of the lawyers? It's possible. It's less likely to me, but it's possible. A number of you asked me if I thought that the leak was a reason for the plea deal. I don't think the leak was a reason for the plea deal. I think no matter how much information is out about a case, with careful jury selection and bringing in a lot of jurors, you can still find people that have no idea. My husband is often one of those people. If you ask him what's going on in DCI at the moment, he will be able to tell you generally what shows he likes. Not by core name, but by either music or prop. He's like, the ones with the curtains. Phantom Regiment. Yeah, that one. The one with the atoms. Yes, Boston Crusaders. I got it. The one with the Pringles can. Santa Clara Vanguard. Yes. But he does not follow most any of this, and it doesn't come across his feed. So the leaked information, he doesn't know anything about it. He didn't watch the Dateline special. We haven't talked about it at length other than a leak happened. So you can always find jurors who just have other shit that they are focused on. It might take a little more time. You might need to find more jurors, but they can. But I don't think it was the reason for the plea deal. I think the reason for the plea from the defense asking for it is because all of the avenues that they were looking for got shut. My weather's getting spicy. All of the avenues they were looking for closed. They wanted to bring in a potential third-party culprit. The court said, you don't have enough evidence for that. They wanted to get some of the evidence tossed out. The court said, no, that evidence is not getting tossed out. They didn't want the surviving roommate to be able to mention bushy eyebrows. Those motions got denied. So the defense went through each and every option. And as all those doors started to close, then it was like, well, if the goal is to keep the death penalty off the table, if that was the goal, I'm not saying it is, but it seems to me that that's part of it. If that was the goal, all the avenues to do that, because the defense kept asking, well, the prosecution didn't turn this over. And in this other case, they took the death penalty off the table because of discovery violations. And the court's like, I found no discovery violations. And no, we're not doing that. Everything the defense did was pushing towards taking the death penalty off the table. And once all those doors closed, then they went to the prosecution and asked for a plea. So I don't think it was the leak. I think it was the judge's ruling. And I think that's fair. So, or I think that's a fair reason for them. Dragonfly said, my uncle was in DCI when I was a teen and we went to see him perform in Boston. From Montreal, he played drums. The uniform included kilts and the whole drum line had no underwear on. That sounds band right. Back, I don't know if they still do undie runs, but back when the band would do like undie runs and stuff, yes. OG drum corps is a little more unhinged than more modern drum corps, but it still has its moments. We will not disclose those. Look, what happens on the bus stays on the bus. I don't even ask my kid. I had friends in drum corps. I had family members in drum corps. I don't want to know. There are things as a parent that I don't need to know. Are you having fun, buddy? Yes. Are you safe and healthy? Yes. Good. GQ4 said, I'm a percussion instructor and I started dutting at random word times. It's definitely a thing. Yes. It just, when your brain buffers, you just start to dut. Anna, congratulations on getting accepted to Wash U Law. Look, Seattle is one of the best places to go to law school. Here's why. The weather often feels like sit inside and read a book weather, and that's all you get to do in law school anyway. So enjoy it. I very much enjoyed being in Washington for the brief time that we lived in Washington. So I very much enjoyed it. Have a great experience. Look, 1L is disorienting. Hopefully through getting to watch trials and all the rest of it, you get to hear a lot more lawyers. I did not get to interact with lawyers before I went to law school in the way that we can interact online. And so there's a lot of lawyers that share how they think about law, how they think about law school. And so the process of like how people think and how lawyers think might not be as disorienting for some going into law school. It's like, wait, what? It's a very different way to think. So your 1L year, you're learning a lot of new information, but you're actually learning a new way to think. And it is difficult. And I imagine it even feels more at odds now with how people interact because it's a much different pattern of thinking, critical thinking, and behavior. So 1L is exhausting because you're actually learning like new ways to think and new information. 2L is so much fucking work. It's just a ton of work. Have processes, stick to your process, sleep, hydrate, move, eat. You have to do those 4 things or you will crash and burn. Set up good habits early on. If it means socializing comes a little less, I get it. Eat, move, sleep, hydrate. 3L gets a little bit more boring. So you got 2 years of a lot of work and then you get to breathe a little bit, but it's perfectly acceptable to nope out of a lot of the social obligations of life because you are in law school. You cannot do it all. It happens. There are times I'm like, I can't do that. I got finals. I'll talk to you guys in 4 weeks. It's time. Elaine said, I apologize to my cat because I have to move him to get up in the morning. That is a fair apology. You have inconvenienced your cat and they are the rulers of the universe. So when it comes to apologizing to the pets, that is not over apologizing. That is just necessary because otherwise cats will hold it against you forever. Shell said, can you please explain the penalty phase? We don't have those. When we're talking about a penalty phase jury, in a case where the death penalty is on the table, the jury goes through the first part of the trial, which is the part of the trial we're familiar with, which is determining, is it a guilty verdict or not guilty verdict? If there's a guilty verdict, then the same jury considers a whole bunch of different information for the penalty. And then the jury renders a verdict on what the penalty should be. And that penalty will either be life, like fixed life without parole, or the death penalty. But that phase of the trial has a lot of different information that comes in that is not information considered to determine a guilty or not guilty verdict. So that's when we get into mitigation and aggravation. You learn other things about the defendant. You see different witnesses in the penalty phase about the defendant, their life, their criminal history, if any. And so it's a totally different trial. And it is often shorter, but there will be witnesses as part of that trial. So Lona said, why is the defense so upset about the gag order being lifted? They didn't want it lifted. They're advocating for their client. I don't know. Virginia asked, will he go straight to prison from court tomorrow? Probably not, because the hearing is anticipated to last all day, and it will take a couple days, often logistically, to get somebody transported. It will not necessarily be tomorrow, but it will be relatively quickly that he will be transported. They will not announce when that will happen due to security reasons. I'm not going to speculate on it, but it's not going to be tomorrow immediately after the sentencing. So, Sherry, can the families take as long as they want? Can they address the defendant directly? Yes and yes. They are often told to address the court. I have never seen a court correct them if they address a defendant as you did this. So it will just depend. But they generally can take as long as they want. There's an emotional exhaustion that goes with that. I've seen most keep it sometimes even shorter than they thought because the emotion is so heavy in that. So still don't know where the horse came from. If we find out, I'll tell you. I don't know if Travis will. No, but if we do, I'll let you know. Laura M said, glad to be here with y'all. Still rocking a 4.0 GPA. Congratulations, Laura. Wild Wind Farm said, my horses would like to join the Cavaliers too. Fantastic. Let's see. Laura M, can you please give an example of persuasive versus mandatory authority? You explain things in a way that makes sense to my brain. Not easily because coming up with cases is not going to help. Mandatory is in the direct chain of a hierarchy, I guess, for lack of a better word. So it's going up the chain of who presides over what. So if you have a chart of which courts are over which charts, it is up that chain. That is the mandatory authority. Persuasive authority are things that are outside that direct chain of hierarchy that may help give information, especially if they're under the same circuit. So a Idaho case is not mandatory to a California court, but it might help them understand the way the Ninth Circuit might see things because they're under the same circuit. If that helps. Alley-oop said, I've been loving catching up on live trial streams. Good. That's why we have these super streams and stuff so that you can. Nina, I don't know this case well. I really, for my own ability to talk about the cases I am covering, do not dive into cases with child victims. So I do not know all the circumstances of that case. Are there other cases pending? Because if there's other cases pending, that can be a reason. So I don't know. Lisa R said, I have the same Bucky I bought while visiting Tennessee. We're starting a trend, Lisa. Let's do it. Radiohead featured my kids' marching show this year. That's incredible, RK. I love it. And we saw Carolina Crown was at Coachella this year, which was incredible. So we will see more of it. It's a great thing. Christina said, have you ever had to testify as a prosecutor? No. I wouldn't think it's common, but now we've seen it twice. It's not common. It's not common. It's not usual. It's not good. I've had to give statements about things, but it was witness statements of, we've talked on members only about the in custody who sprinted for the door. So I gave a statement about what I observed when that happened in the courtroom. Like, where were you? What was going on in court? What did you see? What was said? What do you remember was said? Those kinds of things. There were other things that happened in court where I have said, I saw this thing, but not related to lawyer actions in a case. So observations of courthouse fuckery, yes. But I've never had to testify. Statements, yes. Shit happens in court. So you can end up being a witness to shit that happens in court. I have witnessed things happening in court where I'm like, well, this is what I witnessed. But like a Carrie Morrissey, no, never like that. That's wild. So let's see. Hoping we can follow this. I saw yesterday appeals court ordered a new trial. I have nothing. I have no idea. I will take a look, but it's going to be a minute. New cases are going to be a minute. So Apocalypse DOA says Alaska is 2 times the size of Texas. Yes, but the reputation of Texas is everything's bigger in Texas. So when I'm describing Buc-ee's, that's how I'm describing it. But the vast land of Alaska is not to be underestimated. So let's see. Rachel Mills, I do not know. Rachel asked, how is Baldwin's civil suit? I have not checked in a minute because we've just been super busy. Thank you, Priya. I saw that Buc-ee's is coming to Murfreesboro, and we will see. I don't know if I would go to Buc-ee's all the time when it's closer, because it's like a road trip destination. But it being in Murfreesboro, if you're driving from like, I don't know, anywhere north all the way through to Orlando, which a lot of people do, it gives some good Buc-ee's stops, because if you're driving through from, Indianapolis or Michigan or whatever to get down to Orlando, you have a Buc-ee's in Kentucky, and then you would have the one in Murfreesboro, and then there's one in Georgia. So it would be actually a really good distance. You could just go Buc-ee's to Buc-ee's to Buc-ee's and always have a bathroom within a couple hundred miles, like 200-300 miles. And that would make sense, because then you could do like a Buc-ee's tour all the way down. Like where the one is before you get into Tennessee and Kentucky would make sense if you're heading down to Florida. It makes sense. So lots of Buc-ee's. Let's see. Are we taking other case updates? Not yet. Not yet. We're not talking other case updates, because I have to go so I can prep for tomorrow, and I have physical therapy today for the knee. But we are going to cover the sentencing all day tomorrow. So tomorrow's going to be a pretty long stream. I'm sure there will be lots of questions. I am going to hold questions until we are mostly done with sentencing, or until there's natural breaks in court. So if there are breaks in court, I will take questions then, but we're going to mostly just do the hearing tomorrow. Remember, it is going to be an emotional hearing. It is going to be emotional for me. It is going to be emotional for you. It is going to be emotional for those in court. We are just going to be here and see what happens. It is going to be, I imagine, a hard day. But at the end of the day, what I expect to happen is that the court will sentence Brian Kohberger to 4 consecutive life sentences plus 10 years. I am interested to see if restitution gets handled at sentencing. Restitution can get put over till later. So restitution may not happen tomorrow, but restitution will be part of the sentence. The amount of restitution we may or may not see tomorrow. Also, depending on how many people want to speak tomorrow, it may go into Thursday. If it goes into Thursday, then we will cover it into Thursday. I've made arrangements to make sure that I can do that. And that's what we're going to do tomorrow. Court will generally run from 9 a.m. local time Mountain to 4 around there. And the court will take a shorter lunch break. That's generally what Judge H does. So we will just have to wait and see. It could be a much shorter hearing if people want to present written statements to the court. Those are generally not read out loud. So we will see. We are going to run it on a very slight delay so that we can have closed captioning. Closed captioning is something that I think will be helpful for everyone. And though we did the plea hearing in real time, there was a lot of anxiety around that hearing. So I wanted to do it in real time, and we did a lot of it. But the sentencing hearing, because it's going to be so long, I think giving us the extra 40, seconds so that we can have closed captioning matters quite a lot. So we're going to do that and make sure that we have closed captioning on the feed, because coming out of the court, it will not have closed captioning. We will need to refeed it. So we're going to do that tomorrow. That's the plan for me and Team Baker. So we're going to have that set up and ready to go. Court took a little bit of time to start the last hearing day, the plea day. Court might take a little bit more time to get started if security outside of court is running slow. So if it doesn't start right on time, it's not because anything is wrong. It's likely because they need to get everybody into their seats. So that's what I anticipate. The defense will also have a chance to talk. And we will see if the defense attorneys make a statement, if anyone from the defendant's family makes a statement, if any friends of the defendant make a statement. That can happen. We'll see. I don't know. Will the defendant make a statement? The defendant has the option to make a statement. I don't think that he will, but anything really can happen with that. So the defendant might choose to speak. He might not. We'll just have to wait and see. And then if we have any more information on the grand jury hearing today, or the grand juror that pled guilty today, I will share that out in the app, because I do have to get to PT. So, Law Nerds, you are the best. Thank you for being here. Thank you for being a Law Nerd. We have a very long day tomorrow. Mods, thank you for all your hard work. We are going to have a long day tomorrow. Thank you for helping me stay on topic. Mostly stay on topic. I appreciate it. And we will be doing the same tomorrow. It is going to be a hard day. I think it's important to see the end of the case as well, not just what happens in court. There is a very human part to these cases, and the sentencing hearings tend to be one of the hardest parts of a case. I hope, as my hope is in all cases, that it can allow people to start to move forward and heal, even though the wrong that has been done to them can't be undone. I'm interested to see what people have to say tomorrow and how it unfolds. What I do appreciate is that the judge will keep a orderly courtroom. He is no nonsense, and he will make sure that people have the opportunity to be heard, I hope. So with all of that, Law Nerds, you are the best. I will see you tomorrow in court, 10 a.m. more or less Central Time, which is about an hour before I normally start, because court is at 9 a.m. local time. There may be a little period of time before court starts. If court is not immediately on time and I am a little behind, we'll just give ourselves room. So Law Nerds, I will see you in the morning. If you do not have the Law Nerd app, now is the time to get the Law Nerd app, because if court is not starting on time, we will send out an app notification when court starts if we are waiting. We have had some days where we have waited quite a while for court to start. Yes, we will always tell you in the chat, but we will also tell you in the Law Nerd app. So free on iOS and Android, Law Nerd app. Make sure you turn your notifications on so you see them tomorrow, because we will be notifying you. If you have a very busy day tomorrow, I hear you. It is going to be a long court day. If anyone speaks for the defense, when we switch to the defense time to speak, because the prosecution and victims' families will go first, we will send out an app notification. If anything unexpected happens in court, we will send out an app notification so you can come and watch with us if something happens. If you need to step away, we will let you know. So tomorrow, hydrate, bring your Kleenex, and we will be in court together. Law Nerds, I appreciate you. Thank you for being here. Thank you for being a Law Nerd. Thank you to our sponsor, June's Journey, for supporting the stream and for a game that I really enjoy playing. I hope you do too. So Law Nerds, I will see you tomorrow for sentencing. It's going to be a heavy day, but we've got this. We can do this. We can do hard things. We've done it before. So with that, where is my outro to say goodbye? Bring your comfort, Paw Nerd. I'll see you tomorrow. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. because you never know when something's going to pop off. Thanks for being here, and thanks for being a law nerd.